The December 13th, 2017 meeting of the Municipal Code Enforcement Board is called to order. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Ladies and gentlemen, the Municipal Code Enforcement Board is charged with conducting hearings to determine whether an alleged violation of the city code has occurred. Decisions made by this quasi-judicial board will be based on the evidence and the facts presented tonight. Our meetings are conducted in accordance with Robert's Rules of Order, and each case will begin with the city presenting its evidence of the alleged violations. The respondents will then present his or her case. Both parties will have an opportunity to cross-examine all witnesses. The board members may question any witness. Comments by both parties must be relevant to the case. Persons wishing to speak will be given an opportunity to do so by the chair and must address the board from the podium after giving their name and address. Upon request, copies of materials submitted by staff are available for review. Board members are reminded to obtain permission to speak from the chair. The questions of the city should be directed to the attorney for the city. At this time, I will ask all persons who expect to give testimony tonight to stand and be sworn in by the Deputy City Clerk.
Please raise your right hand. Do you swear or affirm that the testimony or evidence you're about to give or present is the truth, the whole truth, and nothing but the truth?
Cases will be taken out of order to accommodate respondents and witnesses present here at the meeting tonight. First of all, we will have approval of the minutes. Have all board members received the minutes of the November 8th, 2017 meeting? Are they correct? Any corrections needed? No corrections. Okay. I would entertain a motion to approve the minutes.
At this time, I approve the minutes for November 8th, 2017.
Mr. Lloyd, motion, second. Second, Mr. Allen. All in favor? Aye.
Aye.
Opposed? No nays. Okay, what I'm going to do at this particular time is to give you a little report on my last visit to the council meeting on November 21st, and then we will proceed with the lien reduction first. The council meeting of the City of Temple Terrace on November 21st, 2017 presented, where I presented the Municipal Code Enforcement Board lien reduction recommendation. The initial council motion to accept the lien reduction in the amount as presented by the board failed for lack of a second. There was a reference to information at our meeting, in our meeting minutes, referring to things that did not seem to make sense or be square. So, and as the board, we cannot rule on cases based on our personal feelings or hearsay. Our case rulings must be based on information brought before the board. We as board members are free to ask additional questions for additional information from the parties presenting the case. There was new information presented at the council meeting that had not been presented to the board, and we may hear some of that this evening. Another motion was made by the council stating that the lien amount should not be reduced and remain at $126,300. This motion also failed for lack of a second. A third motion was made to accept the board's recommendation of the reduction to $20,063. The motion failed due to lack of a second. A fourth motion was made to reduce the lien amount to $75,000. This motion was seconded, and the vote on the motion was 3 aye and 1 nay. The council had a required quorum, that being 4 members present. However, the quorum requires 3 votes to pass. The motion failed by lack of 3 votes. There were 2 members absent. The matter went back to the city for determination of new direction. The determination was for the lien reduction to come back to the board. We will hear a lien reduction case, lien reduction case first tonight. And Kristen, will you please introduce the case?
Consideration of lien reduction petition in case numbers 13-0187, 16-1433, 16-2328, and 16-2514, City versus Scott W. Waters for property located at 9301 Rolling Ridge Place. The amount of lien totaled to $126,300. The petitioner's attorney will be presenting. Is the petitioner's attorney present? Okay.
I don't
You can
believe,
come on up.
I don't believe you were sworn in.
I'd be happy to swear in. I wasn't prepared to offer his testimony, just our position.
Is Mr. Alvarez coming tonight?
No, Mr. Alvarez is not coming.
Do you swear or affirm that the testimony or evidence you're about to give or present is the truth, the whole truth, and nothing but the truth?
I do. Good morning, or good evening, excuse me. My name is Jeff Tebow. I represent Mr. Waters. With regards to this matter, Mr. Waters is back out of the country and obviously couldn't be here tonight himself. Happy to answer any questions that might be had preliminarily.
Can you give us your address?
Yes, my office address is 20545 Amberfield Drive, Land O'Lakes, Florida, 34638.
Was your last name Peabody?
Tebow, T-H-I.
Tebow.
Yes, T-H-I-B-A-U-L-T.
T-Bolt, okay. Thank you.
I've reviewed the videos of the prior hearings and understand the board's positions understandably, and I appreciate everybody's time and effort and diligence in continually looking into these matters and consideration. And I understand that the lien reduction seems unpalatable, especially a significant reduction. But I think it's important to keep in mind that Mr. Waters was essentially a victim here and has already paid some price, a significant price for, what I guess at worst would be his being too trusting of the individual he was left to care for the home. He's already paid a significant amount as far as remedial work on the property, which I believe it's been uncontested that was done pretty quickly as soon as he actually received notice of the violations and came back from out of the country to do so, again at his own cost, and to put the property up for sale to so that obviously acknowledging that he is not able to adequately ensure that it's maintained when he's not around. So I think it's important to focus to some extent that Mr. Waters didn't choose to be here. It's not like he took a $126,000 loan from the city and now is trying to negotiate a discounted payback. He received nothing from the events that led to this to these liens. Understandably, the city did suffer, as did the residents, and he's done everything he could to prevent any further violations and to remedy the situation, and is proposing a fair settlement, but again wants to be able to sell the home, pay the proposed settlement out of the proceeds at closing of the home, so that the city will be guaranteed at least payment from the title company who's handling the closing, so that a new resident can move in who will be able to live in and hopefully care for the home. The home is appraised for, what I've been told by Mr. Alvarez is the Realtor, for a more substantial list price per square foot than has been in the past. So if anything, this sale will aid the neighboring properties in assisting their, increasing their property value. I understand the city's goal is, with these sorts of ordinances, is to promote compliance, not necessarily just to punish, and I think it's important that that be the focus, because there comes a fine, balance of such excessive fines that it's no longer promoting compliance, but it makes it enable for a homeowner to comply, and doesn't do the city any benefit, as the fines won't be able to be paid. There's obviously some statutory issues with the city foreclosing on a home for this sort of lien. So I think it's a delicate situation that at some point, the excessive fines will result in people letting their homes go into foreclosure, which in this case, Mr. Waters has a superior mortgage. So, there's, I'm actually shocked at his determination to, be as forthcoming and work something out as he is, when I know he could turn around and just, stop making payments on the mortgage and let it go, which would only, the city's goal should be to benefit the city as a whole and not necessarily just focus on Mr. Waters, but avoiding, homes being vacant because they can't be sold, or homes that can't be, they're gonna end up in foreclosure and just left vacant with, vagabonds coming in or who knows what, or just at some point people giving up on being able to afford to comply because they can't, but at the same time they can't dump their property that they may not be able to maintain because of excessive liens. So, our focus would be on getting the property in compliance, which has already been done, and to be able to, provide benefit to the neighboring properties so that, their value isn't hindered, which, at least because of the violations, that's been ceased, but that this property isn't just lingering without being able to be sold and put to some efficient use. So Mr. Waters is offering, I know the last reduction, I believe, was at $20,000 from this board, and we'd be proposing $30,000 to, again, pay at closing, so that the city will actually have some funds, rather than, understandably, the number is $126,000, but at some point, that's not gonna end up with money in the city's pocket. So we believe that $30,000 would be fair, feasible, so that it won't lock the property up to prevent the sale, and to essentially, remove the incentive for him to continue to maintain the property when he's not gonna be able to dump it at some point, which, again, he obviously has some inability to maintain himself when he's working out of the country, so.
Let me ask you, in November, we had a contract that was a for-sale contract.
Yes.
Has that buyer stuck around?
Yes, that buyer is still around at the moment. I believe the date that they've alluded to Mr. Alvarez, or at least stated to Mr. Alvarez, would be through, I believe, the 21st of December, that if they didn't have a go-ahead by then, not necessarily to close on that date, but I believe that's the currently scheduled closing date.
Okay. Should we, when it goes through the board and the rest of the information that we hear tonight, is Mr. Alvarez open to other numbers, or is he?
Mr. Waters?
Or Mr. Waters? What did I say?
Mr. Alvarez.
Mr. Waters.
I mean, certainly, I'll relay to Mr. Waters, and where I understand that the board can make their recommendation. Like I said, I have to commend Mr. Waters, and I know everybody's looking at him as like he, is a criminal for some reason, like he did something to the city or stole money. But again, he didn't want to be here. You know, he didn't benefit at all. If anything, this was only a detriment to him. And you know, as every dollar he pays for, you know, any sort of lien reduction is further detriment. So, you know, and unfortunately, you know, he failed to oversee the person he trusted, and he's paid the price for that. But I have a hard time recommending to him to pay, you know, too much, but he wants to. You know, he wants to make things right. You know, my mind as an attorney is, well, I can put this through a bankruptcy and get rid of it, and, you know, the city can fight for 126 and we can keep talking, or, but end up with zero. And, you know, if we're gonna hold up this transaction for months and months, we need to figure out a better way to handle it.
Right.
You know, and that's what he wants to avoid, you know, and wants to make a good faith settlement, but.
I want to go back to one comment you made about the violations and the not being able to maintain the property because of the fines. The sequence is that the violations occur and the responsible parties do not take care of the violations. And that's when it comes to get the fines accruing. So I just wanted to turn that around
Understood.
because we're on public TV. So I
Understood.
want to let it know. Okay? Are there any other questions? Okay. We'll probably be having you up again. We're going to move on.
Not a problem. Thank you very much.
Thank you. Mr. Barone? Director Barone, would you like to help us out?
Good evening. Tom Barone, Director of Code Enforcement. I'm just going to add a few factors to enlighten you guys as far as what has transpired and things that you guys should know. The 4 cases that were presented to the board were presented by me, okay? In the last case in 2017, when I produced the case to the board, before I generate my notice of violation, I check the property appraiser to make sure the address is still the same address for the mailing of the notice of violation. So, and I also noticed that the homestead exemption had changed in 2017. So it was homesteaded for years, and then in 2017, it wasn't homesteaded any longer. So I think there was a little bit of, you know, as far as Scott Waters taking advantage of the homestead exemption, it was clearly that, you know. So in 2017, his mailing address had changed to Palm Harbor. And also, also from Scott at the hearing said that there was a caretaker at this property. Well, the amount of traffic that was going in and out of this house for years, there was just more than one person occupying this structure and property. In the 11 years, I've had 27 cases at this property. So that's a lot of cases, okay? So as far as the nuisance to the residents, of the neighbors, it was a very sensitive property for code enforcement because the structure was going downward very fast. And especially the last 2 years, the caretaker supposedly sold all the metal that, so he could take care of his needs. So the pool cage was dismantled, the air conditioning units were sold. So when somebody does that, their life is going down pretty fast. So when I used to go by every morning, the windows would be open because there was no air conditioning. So this is the way the structure and the property was going. It was fading very fast. So I just wanted to make sure the board knows that as well as, but when we do our calculation for the lien reduction, I go based on how fast they ramify the violations. And that's based on my calculation. That $20,000 was based on the calculation of the repairs. But I'm adding all this other stuff because this has all come out in the last month or two, and normally we don't do when we do a lien reduction, we don't get this deep involved. So, yes, this has been a property that's been very, very sensitive to the neighbors, and it's been going on for years. So I hope I added some testimony to your thoughts of what you're gonna come up with tonight, but the problem's been going on for years. So if you have any questions for me, I'll.
So I also have heard that there were police call-outs to this property as well. Do you have any information regarding how often?
I don't have any information, but one of the residents in that area
Okay.
produced it at the council meeting, and I believe there was approximately 20 calls made to the police.
The second question I have is there any way to quantify the cost to the city as far as administrative, as far as your cost and police call-outs, in addition to whatever repairs were done? There were some repairs done to the property as well, right?
Yeah, the staff had to go out there when Mr. Damien was the director in 2017. The staff had to go out there and erect and construct a temporary fence to secure that pool. That was also never brought up as well. So these little things that we're talking about now, you can understand the frustration from the neighbors.
I know this is a hard question, but is there any way to, does $20,000 in any way cover those type of expenses? I mean, I know it's hard,
It's,
hard to quantify.
yes, yeah, I really can't come out. Like I said, the neighbor's been dealing with this situation for a long time.
Okay, thank you.
Are there any other questions? Mr. Stats?
Is the city's position still at the 20,000, based on anything you've learned recently?
Since the neighbors came out for the last council meeting, and based on what I'm telling you tonight, no, the city feels that 50% of this lien should be, we're going halfway, and the city is interested in going towards $60,000. So that's the stance or the position that the city's going to take tonight.
Are there any other questions? Thank you, Mr.
Thank you.
Are there any other persons in the gallery that would like to speak? Come on up, please.
Good evening, Annette Rennie, 9512 Woodland Ridge Drive. I am one of those neighbors. We went through this for 5 years. I have a list of some of the police calls, not all of them, because some of the neighbors actually had them come to their house because they were afraid. I will hand them to Bill and he can pass them down.
Board will accept.
We went through not just high grass, but 5 and 6 people living there at one time, some of them living in outbuildings. A pit bull that was allowed to run loose, they would actually open them in the side gate and and it chased a lady. We were told that it was a tenant, then it was a caretaker, and then it was a relative. By Mr. Alvarez's testimony at council, Mr. Waters was in the military serving his country, and I think that's in the minutes. And what he is a private contractor. He is not in the military. He's not serving his country in the military. He also answered the question, Mr. Waters himself, that he received his mail. It was forwarded. Ironically, none of the code liens, none of the things that came from the city did he ever get. There's too many inconsistencies there. And for 5 years, it was not homesteaded. It wasn't homesteaded. I looked it up and also reported the fact that he had it homesteaded. I'm sorry, he had it homesteaded. It did not begin to come into compliance until quite a while after that this summer. There were trucks jacked up in the driveway. The police were out there. It didn't even begin to pay for Tom Baroni's trips to that house by us, by just himself, to care for things. Half the time, they don't answer the door. They would put a shirt on a fence, and several cars would drive up and get something and leave. You guess what it might be, and then the shirt would come off the fence. This went on and on and on. I am not for allowing people like that to get away with it. The night he left council, he was laughing at us. The other neighbor who was here, going to be here to testify tonight had dental surgery emergency today and could not be here. But this is not a person who has been honest, and not to contradict the attorney, however, he's not raising the prices in our neighborhood. That house sold around the corner for $260, and there are other ones that are much higher. So, I mean, I'm in the real estate business. I can tell you just about what every house in that neighborhood sold for. There's just too many inconsistencies and too much dishonesty here. I'm with the city in the $60,000. He owes the city that much, and he certainly owes the citizens who had to put up with this in our neighborhood that and more, because he was totally aware. There was no way he was not aware. Thank you.
Thank you. I appreciate your coming in to share that with us. It was, it would have been better if you'd have come here before you went to the council, but you weren't aware of that.
No.
And so, when I was at the council and I was sitting there and listening to this, I'm thinking, you know, so I do appreciate it. No. Of Annette, of a Miss Redding? Yes. I'm sorry, yes. Please come up again.
So I'm going to ask you another tough job. Since you're the only neighbor here, and just ask you to sort of represent their feelings. Talking about the balance between deterrence and compliance, would the majority of the neighbors be, if it turns out that the $60,000 is not acceptable and the property can't be sold, which is more important to the neighbors, the fine or getting the property moved? Because I think you want a different owner.
You
right?
want to know the truth?
Yeah.
I think that they want this to set a precedent. We are tired of people getting away with this. When someone laughs and they are not honest and they are not upfront, it's like going, okay, it's all right, you can do this. The property will sell. It should have been listed higher if, in fact, everything was done the way it should have been inside. They have it listed, I believe, at $220. Raise the price and put it back on the market, but pay your fines. I mean, we are setting a precedent for other people who are not honest in this city, and there are several, and you know, I don't have to name them, to get away with this sort of thing, and it's wrong.
Okay, I just wanted to get a feel for where the
Okay,
neighbors stood.
thank you.
Okay, thanks.
Is there any other person in the audience that wishes to speak? Does the city want to speak now, or do we want to have the attorney speak again?
We should say, first of all, introduce Pam Chacon, who's the incoming city attorney. As you know, Shoemaker is sunsetting its representation of the city, but you're in capable hands with Pam, and she's intimately familiar with this particular case. I think before we move on to further comments from either legal staff or the city, again, I think we need to give the petitioner another opportunity to respond to Mr. Baroni's testimony and also the testimony of the neighbor.
Right. Thank you.
Thank you. I understand the allegation.
Just give your name as a marker.
Jeffrey Tebow, on
Thank
behalf
you.
of Mr. Waters. I understand these other issues that, appear to kind of exasperate the violation, but again, none of these allegations were acts that Mr. Waters committed, and understandably, he, has a duty to, maintain the property and to know what's going on there. But he can only do so much, from working overseas, and, he's come to that realization, and which prompted his desire to sell the house, realizing that he's been burned by this individual he trusted, and that he's not going to be able to maintain the property himself, obviously, and who's to say that things wouldn't happen again if he trusted somebody else. So that's what he doesn't want to do. But if the the property can't be sold, he has to go to work, so, you know, he's gonna have to find somebody to take care of it or something, you know, to try and prevent any further violations. But again, that won't be in his hands, and, you know, that's what he's trying to avoid. So I think it's important to, you know, keep that in mind and not necessarily fault him 100% as if, you know, this couldn't have happened to anybody who rented out their property with, you know, the correct permits or anything like that, or anybody who let a family member stay there, or anybody whose, you know, kids were there. Well, you know, they went out of, or if they were out of the country, the most wholesome person could, you know, end up being, you know, the worst of the worst. And unfortunately, Mr. Waters, you know, didn't have control over that. You know, that this individual who was supposed to be taking care of the property let others stay there possibly. We don't know for sure. All that Mr. Waters knows is that he trusted this individual who who established some trust with him previously, but obviously got, you know, involved in some things that we'll assume and cause these violations, which, again, Mr. Waters has suffered the price of already. It wasn't Mr. Waters trying to you know, take advantage of the city by any means. You know, if the police had come out, I understand that the police had been called out a lot. If they had found something that was criminal, they should have, you know, arrested those individuals. You know, the tenants or, you know, the residents or whoever's staying in a property is the one who faces punishment for a crime, not necessarily just the owner. You know, if we wanted to solve all murders, we could make the owner of the real estate liable for everything that happens on there, you know, and then give them the duty to prove otherwise, I guess. But to hold that against Mr. Waters, I think, is unjust. And as far as the tax exemption goes, again, Mr. Waters didn't try and defraud the city or to change the exemption. In fact, he didn't change that exemption. As the neighbor admitted, she called the county who removed that exemption. Mr. Waters is entitled to that exemption. This is his homestead. He doesn't own any other real estate. This is where he intended to reside and to come back, even though he's on an extended duration. He's on a work trip, no different than anybody else losing their homestead if they went away for a week-long work trip. His just tends to be longer, and it's out of the country. You know, military personnel or contractors that, you know, work out of the country don't lose their homestead exemption just for going to work for an extended duration of time. There's a process to dispute that with the county. You know, Mr. Waters hasn't been too concerned with, you know, as far as the tax exemption. But the fact that he had it and then has lost it doesn't indicate any fraud on his part by any means. You know, he doesn't own any other real estate in the United States at all. This is his only home, and surely is, you know, where he intended to reside. And the address change, again, didn't indicate otherwise that this wasn't his homestead. It was just that once he became aware that he wasn't actually getting the mail from this individual he trusted, and I think the city manager had previously acknowledged that the notices with regards to the violations all came back, returned, undelivered. So I know the neighbor believes it's inconvenient or somehow that he didn't get that mail, but the city received those back from what I understand. So the address change was only put in place once he realized that what had happened to his property and that he let the wrong person stay there, unfortunately, in hindsight, which could have happened to anybody. And that address was changed to his parents' address so that he could at least have somebody that he could trust better to forward him things, knowing that this was important. And again, I think he's done everything he could do as far as his good faith in trying to remedy this issue since he's actually become aware of it.
Would you concede one point, and that is being he didn't have his address going to his parents' place for 10 years or whatever the number of years is, and therefore he didn't know anything what was going on with his property. It's kind of rare that you wouldn't have any concern about your property. And therefore, but my concession is that police calls to the property, whoever's in your property is they're a part of you because you're letting them be there. You still own the property. And therefore that all these police calls, 20 by Miss Redding and then whatever number it is by the other people that didn't submit, is an impact on the community, the local community especially. And there's no one else responsible for irresponsible people other than the responsible owner. And that's kind of where we are with this because irresponsible it runs rapid if it's never taken care of. And so he could have evicted, he could have gotten these people out of there had he had his address correct. We don't know that he didn't know this was going on, but had the address been corrected on his part, he would have known what was going on.
Understood. But for him to correct his address to somewhere that he would have received it directly would have been overseas.
Well, his
And-
parents, he got the news after his parents got,
You're right. Yeah, understood. But at the same time, that's still trusting somebody else to, which is what he's trying to avoid now.
right.
Again, I completely understand and that he has a responsibility to maintain the property and to know what's going on. My only intention was to point out that what he did wrong was fail to maybe be as skeptical about trusting somebody as opposed to being a drug dealer or whatever himself. I just personally have a hard time faulting somebody who trusted somebody and got taken advantage of the same as the person who actually did the act of taking advantage of them and, possibly doing criminal actions.
Are there any other questions? There being none, have you got any more to say?
No, I thank you very much all for your appreciation and understand this is taken much of your time, and I appreciate the thorough investigation and continued consideration.
Thank you. Can, Pamela, can you pronounce your last name?
Yes, my name is Pam Shoshone.
Shoshone, okay.
So sorry.
That's okay.
Well, I didn't get it if you did say it.
I mispronounced it.
One
Thank you.
thing that we would like to know from Mr. Waters' attorney is the offer of $30,000, is that going to remain open until the next council meeting?
Jeff Tebow for the, Mr. Waters, yes.
Also, whatever the board decides today, we want to make sure that your recommendation is based on relevant information and relevant materials and not things that are just opinion or conjecture. There has been a lot of mention at both council meeting and probably at the prior meeting here about inconsistencies and different stories, but it keeps coming from all sorts of different people. Mr. Waters did appear at the last council meeting. He did get up and he spoke for himself. He answered the questions. So I know that a Realtor apparently appeared for him at the last meeting that you held, and if the Realtor misunderstood possibly the nature of Mr. Waters' employment and him representing what it is, that was hearsay. He wasn't an attorney speaking on his behalf. And so I'm just throwing that out there so that you don't weigh things against the property owner that are perhaps a mistake of somebody else who was not an attorney retained by Mr. Waters to represent him. The police reports, as far as I can tell, were not calls related to the code enforcement the code violations for which the lien has attached. They're for other things, but we're here today to deal with the lien and the violations for which the liens have attached. Whether it was homesteaded or not homesteaded, the city does not feel that that is really relevant information here. It just has nothing to do with the violations. So that's all we have to add. We just want you to make your recommendation based on what's relevant and not what is irrelevant. Thanks.
Thank you.
If I could add, as far as what Ms. Chichon mentioned with Mr. Alvarez, part of the reason why I was brought into this was to clarify those things. And, Mr. Waters did testify, and I believe his testimony should be the only thing that's relevant as far as, being able to testify on behalf of himself. But I believe Mr. Alvarez was just confused on a few details that, to a layperson or, outside of the context of a legal proceeding, wouldn't really seem, too determinative, to call somebody who's staying in a house for free versus somebody who's paying rent. Most people would refer to somebody a tenant. Again, he was unaware of the significance of, there are different terms for different, types of arrangements, and it was just a misunderstanding on his part. But again, that would all be hearsay as far as we're concerned.
I have to agree with that statement, that whether he was a renter, a tenant, a caretaker, a family member, all of those things we heard, and it's confusing.
Understood.
But in the big picture, with the violations, it's almost irrelevant. It leads to the interpretation of deception, but I don't believe, in my judgment, that it was on Mr. Alvarez's part any point of deception. He was trying to represent an absentee owner who he probably got a contract to take care of to get the house in order.
Yes.
And all of the years that this case has been developing, Mr. Waters has never been around, so no contact was made with him. So that's kind of where we are. You can feel the open-endedness of some of the statements that were made.
Absolutely.
And I'm just kind of, stating how this whole thing has come down. And I think tonight we can clear it up, I hope.
We do as well.
Okay, thank you.
Thank you.
Mr. Barone, do you have anything more to add right now? Okay. Are there any other questions of the attorneys of?
So you said that the police reports and some of the other, information is not relevant to the lien reduction that we're considering tonight. Whatever we decide on is going to be given to the city council. Would they be able to take those factors, external factors, into account in modifying whatever we come up with tonight?
City council can take into consideration whatever it chooses to. However, they are going to be considering your recommendation when they consider this again.
Right.
I would like for your recommendation to be based on relevant factors. I can't control what they're going to do. The city attorney can only make a recommendation to them and try to advise them as well as what's relevant and what's not relevant.
Okay, thanks.
Thank you. Okay, there being no other questions, I would like to have a motion. just to buy a little time. As you recall, the cases were cars parking on the lawn, grass and weeds, the fence, and the rubble that was there left after one of the buildings disappeared, things like that. Those are the things that were brought before us. I don't believe I missed any. Thank you. Mr. Stats.
Make a motion in case number 13-0187, 16-1433, 16-2328, 16-2514, City versus Scott Waters. I make a motion to reduce the lien from $126,300 to $63,150.
Do I have a second?
I second.
Second. Any discussion? There being none, all in favor? Aye. Noes, nays? One nay. Mr. Allen, a nay. Mr. Tebow, the board has ruled that there is a recommendation to the city council is $63,000. And if it's paid within 30 days of the council's approval, then if it's not paid, then it will revert back to the $126,300.
Understood.
Okay.
And if approved by the council
At the next meeting, which
next
is
week.
next week,
The 19th.
next Tuesday night, if you could be there, if you,
Absolutely. I suppose that written agreement conditionally releasing that to the title company so that they could close the property within 30 days if that amount is paid
is paid.
at
Yes.
closing within 30 days. Okay.
Yes.
Thank you
Okay,
very
and they will give you some instruction at the council meeting as to the finality of it, but that's our next step.
Perfect. Thank you
Thank
very
you.
much. Thank you for your
Thank you.
consideration and time.
Thank you. Okay, next case. Kristen?
Okay, we will now hear case number 172587, City versus Rodney D. and Connor D. Niebert for property located at 5325 East 131st Avenue. The case is before the board based on an alleged violation of Section 12921 parking residential property. The case will be prosecuted this evening by Officer Buckland. The city is evidence that the notice of violation and notice of hearing were properly served.
Good evening, Stephen Buckland from Code and Compliance. This case was originally proactively initiated by myself on November 16th. The initial inspection noted that there was a truck parked on the front lawn. Previous notice for violation of yard parking had been issued back on October 20th and was hand-delivered to Mr. Niebert on October 20th. And compliance for that particular issue was observed on October 23rd. The address has been warned about parking this year on January 30th, August 22nd, and October 4th, in addition to those other dates. My return inspection for this particular property, let's say on the 16th, when I returned on the 17th, the 22nd, the 27th, and the 30th of November, and also December 1st, other vehicles were observed to have been parked on the property at that time. I would like to present the photographic evidence of those particular vehicles. Exhibit 1 shows a truck in the front yard on November 16th. Exhibit 2 shows a truck on the front yard on November 17th. Exhibit 3 is a car on the parkway grass on November 22nd. Exhibit 4 shows a car on the parkway grass on November 27th. Exhibit 5 shows a car on the parkway grass on November 30th, and Exhibit 6 shows a car on the parkway grass on December 1st.
Board will accept.
And these are the same pictures that are being shown on the screen right now also.
Oh.
For the viewing pleasure of the people that are watching it from home, just so we have so they have an idea of what we're speaking to.
Exactly.
The inspection of the property during the time period from December 2nd through today has not revealed any additional parking violation, and the property is currently in compliance, and at this time, I would like to submit an affidavit of compliance.
Board will accept.
And at this time, the city is just looking for a finding.
Any questions? Is there anyone wishing to speak?
Thank you for your time. My name is Connor Nybert at the property 5325 East 131st Avenue. I'd like to speak on behalf, and I've had the chance to talk with the code enforcement officer on this particular case. I myself am not happy with the situation that it is. I would like a copy of those photos because those are the residents at the house also with me. Just graduated USF. I'm going to try and get the house under shape. I'm trying to sell the place come May, and that's my goal, to just get the property moving. I try to make some preventative measures. I try to inform the other residents that live with me, but they seem to not really care. It's kind of really annoying because last year I installed a new pavement on the side of my house. I have some pictures of some preventative measures that I made, and is that okay if I show you guys?
Board will accept.
Cool.
Do you want to leave us the pictures, or do you want them back?
No, you can have them. I have them on my phone.
And Kristen, can we get copies of the photos for him? Our photos?
Yes, he just needs to contact me.
Okay.
Thank you for that. Yeah, I'm really trying to make the stop. I actually would like there not to be any fines from the situation, particularly because I'm decreasing the amount of people that live in this property. Me, myself, I'm leaving the residence this coming January or February. I'm going to be working in Orlando. So I'm going to be kind of remote from here and don't really have the trust of those people that are living there also right now. I'm also getting rid of another individual that his girlfriend is parked a lot on there in those pictures. So I think it's going to really decrease the amount of people that park on the side of the road, and they'll be able to utilize the extra space that I installed of new concrete. And then also I made like a little gravel side of the road parking spot that kind of made made regulations with Temple Terrace. So that's kind of my spiel on the situation. If there's any questions from you guys.
How many people are you going to have there when you leave to go to Orlando?
Three.
Three?
Three. And right now there's 5.
Mr. Snelling?
So in your opinion, you should have plenty of adequate parking space for 3 individuals. I don't know how many cars they own or how many
No,
girlfriends they have or whatever.
I mean, each person's allowed one guest, and each person has a car. There's also a garage that they're able to use, but there's too much junk in there. So that's kind of another situation I'm trying to address. But yeah, there's going to be 2 less people living in there, and that also kind of means I don't receive money from another extra person. And those fines of $250 a day after this meeting would be very detrimental to me when I try to sell the property in May.
How many cars do you think could you could park on the concrete driveway that you have in the little addition.
I've done it last year, and you can get 5 cars on there. 6 actually if you park it on the one extra spot I made on the side of the road. But besides that, they really shouldn't be parking on the grass. I don't like it. My grass is dying. I'm kind of annoyed. So, and also sometimes they park on the grass, and that's where my septic tank is. That's kind of a reason why my parking situation is really isn't ideal. Most people in my neighborhood have U-shaped driveways, but I'm unlucky and have 2 telephone poles and a very bad septic area. So,
Is anyone going to manage the property here in Tampa while you're?
yes,
if you-
I'm going to be making bi-weekly stops. So that's that all right, I think. Bi-weekly stops. I work in Orlando, so I'm used to the drive. That's where I'm from. Visit mom and dad all the time when I was at school, so I have no problem visiting the kids at the house.
Other question, Mr. Stats?
Just want to say congrats on graduating and the new job, first of all. Are you gonna rent it until you sell it?
Yeah, so that's
Okay.
only for 4 or 5 more months.
Yeah, I would just say, so you don't have this issue down the road, throw it in your lease and say, not my issue, so.
Exactly.
But, again, hopefully it's not a problem, so.
And number 2, Connor, just following on Mr. Stats's comment, is that, and I don't know if you've been informed about the rental permit thing. I'm letting you know right now
Okay.
that you need to go to the city to, being you're not going to be living there, and there's a whole ordinance about rental permits.
Okay.
And you really should go there and get acquainted with that, and for your own good, or
Mhm.
you will be back here probably before you sell the house.
Alrighty, I'll make sure
I'm
to deal
just
with that.
helping you out.
Yeah, yeah, of course. I mean, I'm new. I'm just a graduate, and I was trying to just make sure I didn't live in an apartment. And I kind of wanted to gain home credit and build my own personal, professional self.
We'd like to have you working in Tampa
You know,
and living in the house, because, I mean,
Yeah, I might be doing some big things soon. We'll see.
all righty.
Was it cool?
Thank you.
Thank you so much for your time.
Any other questions? All right. Yes, sir.
I'd like to talk to Steve again.
Okay.
Okay.
Excuse me, Steve, but these
Yes,
pictures
sir.
the man showed us just now, and these things he made, are they up to code as far as?
The addition to the drive, yes, and it is a hard surface, you know, that's connected to the driveway, and that was usually the biggest problem when they start adding parking spaces, that they're not connected to the existing driveway, and that creates issues.
Because you've been out there, but I look at some of those pictures and, wait a minute, they've thrown something down there, but that meets the code. If you've been out there.
Yeah,
that meets the code,
they've
then
been out there where
it's-
they've got a border on it, and it's a hard surface.
All right.
Anything else?
Thank you. Mr. Niebert, do you want to rebut anything? Thank you. Could I get a motion, please?
Based on the testimony of Code Compliance Officer Buckland and Connor Neighbor presented to the board at this hearing and the documentary evidence received by the board, I make a motion that the board find Rodney and Connor D. Nybert in case number 17-25-87 to be guilty of violating sections 12-921 of the city code, but because the property was brought into compliance before the date of this hearing, no fine shall be assessed.
Second.
Any discussion? All in favor? Aye. Opposed? No nays. Yes. Mr. Connor Niebert, you have been, the property, you have been found guilty of the violation,
Okay.
but it's in compliance, there's no fine assessed. However, if it goes out of compliance again, the fine could go into enforcement immediately.
Okay.
So, as a repeat violation.
Yes, sir. I take the
Okay.
full responsibility.
All right,
Thank you.
thank you.
Okay, we will take the next case. Case number 172830, the City versus Resi SFR Sub LLC for property located at 605 West River Drive. The case is before the board based on alleged violation of Section 810212 electric systems maintained in good repair. The case will be prosecuted this evening by Director Brony. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Tom Baroni, Code Compliance. This case this evening was generated from an email complaint that I received on November 6, 2017, from the tenant that she had some electrical issues inside her rental property. My inspection on the 7th of November with the building inspector, Amir Anisi, noted exposed wires on the interior walls and ceiling. Tenant did state that the preservation company sent out a worker to fix the electrical issues and left the wiring exposed and never returned to fix the issues. That same day, I prepared a notice of violation with the compliance date of November 25th, 2017. I posted the notice at the front door of the violation and requested copies be sent out certified in first-class mail. I also requested a copy be posted at City Hall for the 10-day requirement. I sent out an email to the tenant on November 27th, 2017, to see if the status of the violations had changed. On the tenant's reply on the 28th noted no change. At this time, I would like to submit photographic evidence of the violation that was taken by me on November 7th, 2017. I'd like to
Board,
submit.
board will accept.
Exhibit 1 shows the exposed wire on the side wall. Exhibit number 2 shows the wiring being exposed up on the ceiling. So since I'm not really an expert in electrical wiring, I took the building inspector with me, and that does not pass. So,
It's not a good thing.
as of today, there has been no change, and therefore the property remains out of compliance. And the tenants are here tonight to, if they have any questions, if you have any questions for them.
I have questions for you.
Okay,
The two boxes that were shown, the wall and the ceiling,
right,
or, obviously there were fixtures there
that's correct,
that have been taken down.
right.
Perhaps you don't know the answer to this, why they were taken down?
I have no idea, but I know the preservation company came and removed them based on the testimony what the tenant told me.
Thank you.
Okay. Yes, sir.
Mr. Barone, I remember this case came before us in September because of a roof issue.
That's
Has that
correct.
been resolved?
No, there's a running fine there.
Oh, okay. Okay, thank you.
You're welcome, sir. Everybody else okay?
That's it.
Thank you.
Thank you. The other parties wishing to speak? I don't believe you were sworn in. Please be sworn in, and then we'll take your name and address.
Yeah, we'll just have to swear you in since you just arrived. Do you swear or affirm that the testimony or evidence you're about to give or present is the truth, the whole truth, and nothing but the truth?
I do.
Name and
Yes.
address, please.
Hi, my name is Shirley Lee. Address 605 West River Drive, that's Temple Terrace, 33617.
And are you both going to speak, or who's going to be first?
Well, I just wanted to just state that, you know, we're very exerted in the situation. Like the gentleman said, we were here in September. We're back here now tonight. And it's just ongoing situations, you know, with the property. Now, being it's cold, even running the AC, AC heating unit, we're getting sewage smell, you know, from the heat part of it. When we was running the air conditioner, it was fine, but now when we turn the heat on, we're getting sewage smell. And it's like, you know, from one extreme to another, we just, you know, just really exerted. And, you know, being that we have Altisource, Real Home Solutions, / a landlord involved, they're not doing anything, they're in non-compliance, you know, with the violations. the roof and the electrical system. And even, we have medical documentations of 3 family members who, have upper respiratory infection, and we have stench, the house is stink, just the smell, of like a damp smell, and it's just, like I said, it's just
Can
ongoing.
I interrupt you and make a comment?
Yes, sir.
Because it's important to get on to this one. You mentioned about the smell when the heat comes on. If there is a time that you can be out of the house for a time, and you turn the heat on, because usually, it's almost seasonal up north and here, that during the summer, you're going to get dust on your heating elements, and you're going to have things accumulating, and when you turn your heat on for the first times, you're going to smell an odor,
Okay.
which is that dust and stuff burning off. And so if that's what it is, sewer smell shouldn't be coming out of an air conditioner.
We're
But
smelling sewage. It smells like egg when we're sleeping at night with the heat on, and it's like you wake up, and it's waking you up, the smell even, so it's bad.
Okay. All
It's
right,
really bad.
go on.
Yes, sir. So, like I said, we're just exerted. We do have a little baby there. She was also diagnosed with the upper respiratory infection as well. So it's 2 adults plus the child. And like I said, with Altisource and a landlord, they're not, they're in non-compliance. I mean, it's like, what do we do?
Okay.
And, I mean, we don't know what to do. We're trying to get out the property. We want our money back, that we've invested, because we've been miserable since we've been there. It's not been
How long have you been there?
since March. And when we
Since
went there March, the first month we was there, like we had the sewage problem there. They had to do the septic thing, and then it's just like every 3 months it's been something that we're, up against at the property. And it's
Is
3
your-
ladies there, it's like we're on time with our rent. We're paying our rent. And it's really bad. It's not good for us.
Okay. Would you like to speak?
I
Okay.
think she's basically
Are there
covered.
any other questions? Mr. Stats?
Is the landlord or whoever it is, are they responding to you at all?
If you mean responding by sending out contractors or different people that claim to be contractors to take pictures, but nothing ends up resulting from that, then yes, that's how they're doing it. And it seems to be every time that the rent is about to be due, and we get, we'll get a quote for you guys, and then we'll get back to you, and we pay our rent with expectations that they're gonna do what they're supposed to do, and it's just a never-ending cycle. So in that respect, yes, they are responding, but does anything come out of it? No, sir.
Ma'am, could you state your name and address?
Sorry, my name is Samis Lee, and the address is 605 West River Drive, Temple Terrace, Florida 33617.
Thank you.
Yeah, I was just gonna say, I'm no attorney by any means or anything like that, but there's certain guidelines that you can take through, I'm sure, Hillsborough County or whatever it is for the rental agreements and stuff like that, and the city attorney would probably be able to recommend you to where it is.
you can contact Bay Area Legal Services and make an appointment.
Okay, thank you.
Thank you. Should we share that we signed?
Well, we did actually send out a letter to their corporate office threatening not to pay rent until those issues were resolved. And even in that situation, they were trying to just kind of get us out of the house and get away with the issues that they have and kind of ignore it. So that we've gone that far.
Is this just a single-family dwelling, one house?
Yes, sir.
Okay. Any other questions? Mr. Snelling?
Just curious about the history of the electrical fixtures. When were they removed, and do you know why they were removed? What's the story behind that?
I want to say it was around June, mid-month, part of June.
It was based on a complaint that you had, or they just showed up and?
No, we complained.
Based on a complaint, they brought contractors out and said that there was some hot wiring issues,
And the only thing they did with that was, again, took pictures and then removed the light sconce and whatever was in the top of the ceiling, and that was that. And they left the wires exposed as is.
So you had some problems, I mean, the lights flickered, or you,
It would shock you if you
Shock
tried
you.
to.
Yes, because we didn't actually have the switch. We had to make contact with the sconce to turn it on from a nozzle, and it would give us electrical shock.
okay, thanks.
Okay. Anything else?
No, sir.
All right, thank you.
Thank you.
Yeah, he's coming.
Just want to say thank you, and just 2 cover plates, probably $1.50 each, cover plates, the problem would go away.
I know where they can get them. Mr. Stats
Okay.
has a question for you.
Yep.
When the building inspector or building official was out there, did he have any other concerns about this being an immediate issue?
No,
No.
no. He just said this is a violation,
Okay.
and basically, so that there's wire nuts on it,
Yeah.
so it's pretty somewhat safe.
And
So, and it's away from, the baby's small, so the wires are pretty high up on this wall and ceiling.
and I know there's the alternative case for the roof.
Yeah.
Is that situation getting worse, I would assume, or?
I would guess so, but I did get a phone call this week from the property manager,
Okay.
and they told me they're addressing that violation.
Okay.
But then I mentioned about the electrical, and she said, I know nothing of it.
Okay.
So,
All right.
okay, thank you.
He's got a question. Yeah, I had a question for Tom.
Oh, I'm sorry.
That's okay. About, I guess it was whether actually been able to reach the property management company.
They reached out to me
Oh,
this
okay.
week, so that's about it.
Okay.
Thank
Any
you.
other questions? One comment. Just state your name, please.
Shirley Lee. Since the builder inspector came out, they have sent someone out, and the person that they sent out, he says throughout the home, the reverse polarity. He says throughout the home, because he was checking like socket units, and he says just throughout the home. And he said he don't understand how they wired the home like that. So to respond to that, you know, that they're responding, they're still not doing anything. They may be reaching out to them, but we have to reach out to them. We've been doing our part. So it's like when we reach out to them, then they'll go to code enforcers, like, you know, so it's just been a little game that's been going back and forth.
Okay, thank you. Tom, I have a question for you now.
Yes, sir.
Being you have been able to get contact with the people that are, the preservation company or whatever it's going on?
They reached out to me, so.
Okay, they reached out to you, so
Yes.
can you reach back to them and
No,
you can?
I don't have a telephone number for them. They
Okay,
called my office, and it was transferred to my phone, my cell phone, because I was out in the field. So all I got is my office number.
okay. Put the recorder in your pocket, so when you get that call,
I don't have a.
because they can take care of that without any great issues,
I agree,
so,
I agree.
thank you.
Thank you.
Okay, there being no further questions, entertain a motion.
I'll make a motion.
Mr. Allen?
Based on the testimony of Code Compliance Director Tom Baroni and Mrs. Lee presented to the board at this hearing, and the documentary evidence received by the board, I make a motion that the board find Resi SFR Sub LLC, care of Real Home Services Solutions, in case number 17-2830, to be guilty of violating sections 8-102 subsection 12 of the city code, and give the respondents until
January 10th.
until January 10th. Thank you, Mr. Stats. To come into compliance with the code sections in question. If the property is not brought into compliance by that date, a fine of $200 per day shall begin to accrue on the day following compliance date and continue to accrue until the date that the violator provides the city with evidence that the property has been brought into compliance.
A second? Mr. Snelling, second. All in favor? Aye. Opposed? No nays. We've assessed a fine to the owner of the property $200 a day to begin on the 10th. If they don't get things fixed, the fine will be accrued against the property. There is a, she's had enough. There is a lien accruing on the property for the roof, but it just keeps going, adding up, like you sat through the lien reduction that we had earlier. Hopefully it doesn't go on that long.
Yeah, I think that one was $250 a day, I believe, for the roof, isn't it? So,
Okay,
September, October,
next
November,
case,
December.
please.
Yeah, they probably owe a crap load of money.
Case number 172737, City versus Betty J. Owens for property located at 505 Brentwood Drive. The case is before the board based on alleged violation of Section 81022, hot and cold water supply, Section 81021, sanitary facilities required, 2291, city garbage service required, 81013K, hardware screens, duty to maintain, Section 81014A, fences maintained in good repair, and Section 8102118A, sanitation shared area maintained in good repair. The case will be prosecuted this evening by Officer Silva. The city is evidence the notice of violation and notice of hearing were properly served.
Good evening. Jose Silva, Code Compliance Officer. This case originated on October 12th when a neighbor called Code Compliance Director Tom Baroni concerned about the wood fence along South River Hills Drive being in disrepair. I met with Director Baroni to discuss the case and look at the previous inspector's notes on this case. His previous inspector indicated that this home was a foreclosure. At that point, while discussing the case with Director Baroni, I advised him I had just driven by that residence on October 12th, and there was 2 vehicles parked in the driveway of the residence. Check was conducted through customer service, and it was discovered that city services had been turned on at the residence. Was able to come down to customer service and obtain a copy of a lease that was signed by Robert Owens to the tenants, allowing them to lease the property. Later that day, based on the notes that were from the previous inspector, I was able to contact Patricia Nichols, which is the daughter of Miss Owens, the owner of the home, and inquire about if the home was leased, since the county records indicated the home was in foreclosure. She indicated that the home was not being rented or leased, and I inquired about the status of Robert Owens. She advised that was her father, who had passed away several years ago. On October 23rd, the city services to the residents were terminated, so there's no running water or garbage to the residents. Waited 72 hours, and on October 30th, I prepared a notice of violation with a compliance date of November 14th. The home was unoccupied, so I posted the notice at the home as well as City Hall and mailed copies, both certified and regular mail, to the address and to the mortgage company. My inspection on November 14th revealed no change. The home was still occupied. I'd like to submit 4 photographic evidence of the problems at the property. Going to be photos of the fence in disrepair, torn pool screen, and unmanicured vine growing at the residence.
Board will accept.
As of this date, there's no change. The home is still occupied.
Have the people that are in the home, have you talked to anyone?
On November 16th, Ms. Duran called, and I spoke to her on the phone, and it was not even speaking, it was more of a one-way conversation. She was just venting more, and I couldn't get in much in with her, but I advised her the easiest way to resolve this issue was to bring the person who signed the lease in so we can talk to them. And at that point, she just became very belligerent and hung up the phone on me.
Do you have any questions? Please, Mr. Stutz.
You said you got a copy of the lease?
I got a copy of the lease from customer service
And when was that lease good for?
for a year.
But it was still active?
It was signed October,
Okay.
October
And the daughter said she had no idea about any lease?
that is correct.
Okay, I was just,
And the daughter's here tonight.
okay. Just making sure. And then the people are still currently living there?
Yes, sir.
With no water, no nothing?
Well, no water. They do have Tico. There's
Do they
electric.
have power?
They have power.
Okay. Thank you.
Thank you. Any other questions? Thank you.
The person that, Mrs. Durand, I think you said, is that the person who had the lease is made out to?
It's made out to her and her boyfriend/husband or significant other, but the name is Vieto is the gentleman's name. And I have a copy of the lease here and a copy of when the water was locked out by the city.
Are you planning on submitting them? Board will accept?
We were able to use some other records and look at the signatures by Mr. Owens, and they're not the same signatures that match up.
It's hard, it's difficult.
So did you mention what the relationship between this person Durant and this Owens, or is there any,
I've never met him.
so you don't know why they're on the lease or anything else?
No, sir. The one phone number that's supplied in the front of, on the front of that lease for the contact for the owner is no good. I've called it. It does, comes back no good.
But the owner is Betty Owens, is that,
Betty Owens.
and you've spoken to her or not spoken? You've spoken to her?
I spoke to her the week of, after this. She's 86 years old, so I've been speaking to her daughter who's here
Okay.
right now.
And you said she had no knowledge of the lease? or-
She has no knowledge of the lease either.
And just out of my own curiosity, under what conditions does the city turn off water? What, they just didn't pay their bill, is that the,
A fictitious lease.
oh, okay.
It's, speaking with the mortgage company, it's been a ping pong game trying to actually pin someone down for anything. Finally started getting feedback from them when they were served with the notice of violation. Basically, the attorney I was able to get a hold of the attorney that is handling the foreclosure, and it's at a stalemate now for 90 days since Hillsborough County was considered a disaster under FEMA. All HUD foreclosures have a 90-day moratorium that they've stopped. So they won't start again foreclosure proceedings until the beginning of March.
So, once the foreclosure proceedings go into effect, say 90 days from now, and the bank finally takes over, and then we get rid of the tenants, rightly, wrongly, but they're still there, this can go on for a long, long, long time.
Yes, sir. And he, basically, Mr. Bennett, with the attorney's handling, said could be looking at September 2018 before it's completely gone through the court system.
Ms. Nichols, do you want to speak on this? You will be back up. You will be back up. You.
Yes, sir.
Ms. Nichols is going to speak here first, and
Okay.
then we'll have you back. I got to get your name engraved here on my,
I couldn't hear, sir, out of one ear, so.
Hi, I'm Paula Nichols. I reside at 2015 Bryan Road, Brandon, Florida, 33511. I'm the daughter of Betty Owens and power of attorney. I have a copy of my dad's death certificate from March 27, 2015. He definitely did not sign the
did
lease.
not sign it.
I have a copy of the walkaway papers that, the official ones that my mom signed on January 12th of this year, walking away from the property. It is a non-recourse loan. She's not liable for anything. I've been assured multiple times by the reverse mortgage company.
Oh, it's the reverse, okay.
Yeah.
Can I ask a question then, because I have no experience with reverse mortgages, but maybe you can enlighten me quickly. Being this property is a reverse mortgage, and this property is in foreclosure, wouldn't that mean that the reverse mortgage company is responsible for the property?
Originally, the contact I spoke to there said that they were responsible and that they would have to start the eviction proceedings.
Yeah.
When I called back a couple weeks later, I was told that was not correct, that since the process hasn't completed and her name is on it, technically, she has to do it. So I've contacted an attorney, but that hasn't begun yet. We have to pay to get these illegals out of our house,
Right.
apparently. Mom moved out June 4th of 2016 and moved in with me. We put the house up for sale. It wasn't happening, several months. With the reverse mortgage, the interest payment was $1,000 a month, and so it wasn't feasible. So we took it off the market, did the official walkaway at the beginning of this year, and we were done. We turned off the utilities at that time. We had kept them going for 6 months, kept the maintenance on the property going, and once we did the walkaway, of course, we turned everything off.
Hi, Ms. Nichols. My name's Tim Garding. I'm with the City Attorney's Office. Were you planning on submitting the documents you referenced to the board for
Yes.
to review and as evidence?
Yes.
And would you mind if
No, I
we-
have my, I don't know if you
reviewed
need
them?
power of attorney papers also, or,
I'm more interested in the document you received from the bank, the walkaway. I think you called it the walkaway
yes,
documentation.
I have that, yeah.
But I
Up
think,
here, or-
if you don't mind,
Sure.
and then, I'm not sure if the board wants the death certificate.
Oh.
Okay.
Do you, being we have a false rental agreement, that would mean that we don't have water, sanitary, garbage, all of those necessities, but they still have electric
Yes.
in their name.
It's my understanding it's in their name. I don't know that for sure. I'm
probably
assuming
is.
it's the same name as when the water was initially turned on. They showed the same falsified lease
Yeah.
to Tico.
yeah, right. But Tico hasn't
No,
done anything to assist,
no.
or not. Yeah. Okay. Any other questions? Thank you, Ms. Nichols.
Thank you.
Any other questions? Mr. Garding, are there any comments that we need, anything we need to know?
I don't think so. If Ms. Nichols, was this the only copy that you had?
No,
Okay.
that's an extra copy.
Okay, we'll submit it to the board.
Okay, board will
We have no
accept.
objection.
Okay. Well, I better wait. Were you asking a question, or are you good?
If there's,
Well, is it something we can use in discussion, or do you?
yeah, we can wait, sure.
We need music.
I would like to say that,
Ms. Nichols?
yes. Paula Nichols. When my mother left the property, and even at the beginning of the year, January, the screen was intact. I'm going to assume that's probably where they came in. I don't know, into the house. Somebody broke into the house initially. The screening was completely intact, though. The fence had some issues, but
Okay.
Ms. Nichols, before
Another
you
question.
sit down, may I ask you a few questions? Does your mother own any other property within Hillsborough County?
no.
Okay. Okay, so this is her only property.
They built the home in 71. They've been Temple Terrace residents since 59. Yeah.
Okay.
Any questions? No questions? Being there are no questions, could I get a motion, please?
I had a question earlier.
I need a motion.
Oh, okay.
Anyone? More music. Mr. Stats?
I'll make a motion. Based on the testimony of Code Compliance Officer Silva and Mrs. Nichols, presented to the board at this hearing and the documentary evidence received by the board, I make a motion that the board find Betty J. Owens in case number 17-2737 to be guilty of violating sections 8-102, 22-91, 8-102 subsection 13 subsection K, 8-102 subsection 14 subsection A, 8-102 subsection 18 subsection A, of the city code, and give the respondents until January 10th, 2018, to come into compliance with the code sections in question. If the property is not brought into compliance by that date, a fine of $150 per day shall begin to accrue the day following compliance date and continue to accrue until the date that the violator provides the city with evidence that the property has been brought into compliance.
Is there a second?
Yes, I'll second that.
Mr. Newkirk, second. All in favor?
What about discussion?
Oh, discussion, I'm sorry, take them back.
Yeah, my question is, who, the fine will be assessed against Ms. Owens? Is that who would pay the fine?
The property.
What does that mean, the property?
It's against the property.
Against the property. If it goes into foreclosure or whatever they're gonna do, our lien would be attached to it. The mortgage lien, the government liens will go first, and then ours.
Okay.
Okay, motion,
Just reminds me of a case we had, I don't know, 2 years ago over on Mission Hills, I believe it was, where we had a tenant with a fake lease, or supposed tenant with a fake lease, and squatters basically in there, and I forget how long it took, I don't know, 60 or 90 days to finally get them out of there, I believe, or. And I think, same situation too, I think the water had been shut off, if I remember correctly, and,
it's 3 months after the bank takes action.
Yeah, it's kind of disappointing that they were notified in January and they haven't done anything, and here it is December, they haven't done anything to do something about the property.
Any other questions? We have a motion, a second. All in favor? Aye. Opposed? No nays. Ms. Nichols, a fine has been assessed to the property of $150 a day for these violations. What I would recommend is that you get with your contacts, going back to the reverse mortgage company or whoever else you got next, that's the bank that you're dealing with, that's foreclosing, and let them share this information with them. It's gonna go to them eventually.
Chairman
Mr.
Schmidt, may I
Gardy?
make just one comment? One of the things that respondents sometimes don't understand when they come before the board is that the lien that you, the fine that you assess on this particular property not only becomes a lien on the property in Temple Terrace, which is the subject of this case, but it also becomes a lien on any other property owned by the respondent in Hillsborough County. So I would remind Ms. Nichols, to the extent that she believes that her mother may own other property in Hillsborough County, that the lien will attach to that property too. You know, notwithstanding whatever arrangement has been made with the mortgage company, who is obviously taking the stance that they can't evict these people, the lack of action on the part of Ms. Nichols or Ms. Owens could result in the lien being attached to a different parcel of property. So if that provides some incentive for them to, you know, pay for an attorney to have these folks evicted, it may be
And
worth it.
she's aware of that.
I just wanted to make that announcement, just so so Ms. Nichols was aware.
But Ms. Nichols did state that they don't own any other property. However, being Ms. Nichols is, now, I don't, legal advice out of school, I guess, but does Ms. Nichols being, representing her mother as her, her
The only reason we mention that is, I don't think so. The only reason we mention that is because on the property appraiser's website, there's another Betty J. Owens who owns a parcel of property in Riverview, so.
Okay. Well, you can sleep better tonight.
Not related.
All right.
No, there wasn't another.
Thank you. Any other comments, questions? Okay, next case, please.
Case number 172060, City versus SWH 2017-1, borrower LP for property located at 8203 Broward Place. The case is before the board based on alleged violation of Section 810213B, exterior walls maintained in good repair. The case will be prosecuted this evening by Officer Silva. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening. Jose Silva, Co-Compliance Officer. This case originated proactively September 18th. My inspection revealed overgrown front yard and exterior wall siding that was deteriorated on the front of the residence. This time I issued a door hanger with a compliance date of September 25th. My inspection on September 25th revealed no change. So I scheduled a second inspection for October 5th. On my second inspection on October 5th, revealed the grass was cut, but the exterior siding to the residence was not repaired. I prepared a notice of violation with a compliance date of October 20th. The home was unoccupied, so I posted the notice at the home as well as City Hall and mailed copies, both certified and regular mail, to the address. My inspection on October 25th revealed no change. Prior to filing for the code board on November 14th, I discovered a change in ownership to the property occurred. I issued a second notice of violation with a compliance date of November 24th, 2017. Again, the home was unoccupied at this time, so I posted the notice at the home as well as City Hall and mailed copies, both certified and regular mail, to the address. My inspection on November 27th revealed no change. This time, I would like to submit a photograph of my inspection on November 27th.
Board will accept.
As of this date, the property has come into compliance, and those issues have been repaired. I'd like to submit an affidavit of compliance.
Board will accept. Any questions? I will entertain a motion.
Based on the testimony of Code Compliance Officer Jose Silva presented to the board at this hearing and the documentary evidence received at the board, I make a motion that the board find SWH 217-1 borrower LP in case number 17-2060 to be guilty of violating sections 8-10213B of the city code because the property was brought into compliance before the date of the hearing. No fine shall be assessed.
Second by Mr. Stats. All in favor? Aye.
Aye.
Opposed? No nays. I just want to state, tag on to that one, that there were no people, no persons in the audience wishing to speak.
Next case is case number 172440, City versus James B. Burns, for property located at 602 Courtney Drive. The case is before the board based on the alleged violation of Section 1034 sanitation, keep premises clean. The case will be prosecuted this evening by Officer Silva. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Jose Silva, Code Compliance Officer. This case originated proactively October 10th. My inspection revealed an overgrown condition in the front yard of the residence. At this time, I issued a door hanger with a compliance date of October 14th. My inspection on October 14th revealed no change, so I rescheduled a second inspection for October 25th. During my second inspection on October 25th, there was no change, so I issued additional door hangers to include the carport accumulation with a compliance date of November 3rd. My inspection on November 3rd revealed no change. A notice of violation was issued with a compliance date of November 13th. The home was unoccupied, so I posted a notice at the home as well as City Hall. I also mailed both certified and regular mail to the address. My inspection on November 14th revealed no change. This time, I would like to submit photographic evidence taken of the violations by me on November 14th.
Board will accept.
Photo number one is going to be overgrown underbrush, hedges, weeds impeding gutters. Number two is going to be overgrown hedges, yard debris, and trash accumulation on the porch. Number three is going to be carport accumulation clutter, along with number four. The only change that has occurred after they received the notice of violation, the front yard was cut, and the refrigerator on the carport has been removed from the property.
Has the other debris been removed from the,
Excuse me, sir?
has the other debris been removed from the carpet?
Nothing's changed, except the refrigerator being removed. The yard still looks like that. The front porch looks just like that still to this day.
Question? Mr. Allen?
When you said that the home was unoccupied, did you mean nobody was home at the time of your inspection?
That
or
is
it's
correct,
empty?
sir. No one was home at the time of my
So
inspection.
people are actually living
People
there?
are living there.
Okay.
Mr. Snelling?
And have you had any conversation with the owner, Mr. Burns?
No, sir.
Have you attempted to contact him?
No, sir.
Any other questions? Are you looking, well, obviously you're looking for a finding of some sort.
Whatever the board decides.
Mr. Stats, do you have a question, or are you getting ready? Okay, thank you, Mr. Silva. Okay. I can't tell because your questions are usually late, so bear with me. There being no other questions, I call for a motion.
I'll make a motion, Mr. Chairman.
Motion, Mr. Allen.
Based on the testimony of Code Compliance Officer Jose Silva, presented to the board at this hearing, and the documentary evidence received by the board, I make a motion that the board find James B. Burns in case number 17-2440 to be guilty of violating sections 10-34 of the city code and give the respondents until January 10th of 2018 to come into compliance. And a fine of $200 a day shall begin to accrue on the day following the compliance date and continue to accrue until the date that the violator provides the city with evidence that the property has been brought into compliance.
Is there a second?
I second.
Any comments? Motion's been made, seconded by Mr. Westfall. All in favor? Aye. Opposed? No nays.
The next case is case number 172613, City versus Dudley A. Black for property located at 9408 Hidden Ridge Place. The case is before the board based on an alleged violation of Section 10.3B sanitation grass weeds and Section 10.35 sanitation abutting property. The case will be prosecuted this evening by Director Brony. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Tom Baroni, Code Compliance. This case originated proactively on October 23rd, 2017. My inspection that morning noted overgrown weeds throughout the yard, weeds impeding the sidewalk surface and the driveway and the sidewalk concrete with mildew. At that time, I issued 3 door hangers with a reinspection date of October 30th, 2017. My reinspection on November 2nd noted no change, therefore a notice of violation was prepared and issued that same day with a compliance date of November 17, 2017. The home appears to be unoccupied, so I posted the notice at the front door and requested copies be sent out certified in first-class mail. I also requested a copy be posted at City Hall for the 10-day requirement. On the 21st of November, my reinspection noted that the yard was partially mowed, but still remained out of compliance, and the impeding sidewalk weeds and surface also remained out of compliance. At this time, I would like to submit photographic evidence that was taken by me on November 21st, 2017.
Board will accept.
The exhibits show a mildew and stained driveway. Exhibit number 2 shows notes of mildew sidewalk and weeds impeding the sidewalk. And exhibit number 3 notes the overgrown weeds in the side yard. As my inspection today, the front yard has been mowed and the front sidewalk has been edged, but the side along River Ridge Drive noted no change and therefore the property remains out of compliance. It's a corner property and the side yard still remains out of compliance.
Any questions for Mr. Barone? Mr. Allen?
Is this a rental property, Tom?
No, this is owner occupied and
Just noticed the address was different from the mailing address, so.
you know, I've never met anybody there in the 10 years I've been here. Never met anybody, but we do have a running fine against the side wall. It's stained as well, and that's been going on for about 6 months now. So.
Okay.
There are just some properties you can't figure out what's going on there. You know, but I've never met anybody there.
Are there any other questions? Thank you, Mr. Barone.
Thank you, sir.
Call for a motion. There's no other people wishing to speak. So I call for a motion.
I'll go for it.
All right.
Mr. Westfall,
Yeah. Based on the testimony of Tom Barone, presented to the board at this hearing, and the documentary evidence received by the board, I make the motion that the board find Dudley Black in case number 17-2613 to be guilty of violating sections, let's see, section 10-3 subsection B of the city code, and give the respondents until January 10th, 2018, to come into compliance with the code sections in question. If the property is not brought into compliance by that date, a fine of $150 shall begin to occur on the following date of compliance, and to continue to occur until the date that the violator provides the city with evidence that the property has been brought into compliance.
just clarification, was that $150?
Yes.
Second. Motion and second. Any discussion? All in favor? Aye. Opposed? Nay, no nays.
The next case is case number 172735, City versus Superior Housing Authority LLC for property located at 5401 Rainbow Drive. The case is before the board based on alleged violation of section 12921, parking residential property. The case will be prosecuted this evening by Officer Silva. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Jose Silva, Code Compliance Officer. This case originated October 28th by Code Compliance Director Tom Barodi, who noticed a vehicle parked on the yard grass. On October 30th, I issued a notice of violation with a compliance date of November 6th. The home was unoccupied, so I posted notice at the home as well as City Hall, and also mailed copies certified and regular mail to the address. My inspection on November 6th revealed no change. This time I would like to submit photographic evidence of the violations taken by me on November 6th, 15th, and 18th of November.
Board will accept.
Exhibit number 1 is going to be a blue truck parked in the side yard on the grass. Exhibit number 2 is going to be a white vehicle parked on the yard grass. And exhibit number 3 is going to be a truck parked next to the house on the yard grass. Since November 20th, I've been checking the house daily. I've spoken to the owner of the residence. He has gotten with the renters there, and the problem has been corrected. This time I'd like to submit an affidavit of compliance.
Board will accept. Are there any other questions? Call for a motion.
I'll take it. Based on
Mr.
the
Scott.
testimony of Code Compliance Officer Jose Silva, presenting case number 17-273, oh, wait a minute, wrong case. Is that, no, that's it, isn't it? 17. Yeah, 2735. Presented to the board at this hearing and the documentary evidence received by the board. I make a motion that the board find Superior Housing Authority LLC in case number 17-2735 to be guilty of violating sections 12-921 of the city code, but because the property was brought into compliance before the date of this hearing, no fine shall be assessed.
I'll second.
Motion made, seconded by Mr. Newkirk. All in favor? Aye. Opposed? Nay. None. Moving right along.
Case number 172746, the city versus James Stevens and Glenn Johnson for property located at 104 Holland Avenue. The case is before the board based on an alleged violation of section 12924, parking and operative vehicles. The case will be prosecuted this evening by Officer Buckland. The city has evidence that the notice of violation and notice of hearing were properly served.
Yeah, Stephen Buckland with Code Compliance. This case originated back on October 31st, 2017. The initial inspection, I noted a red Honda on the front lawn without a license plate on it. I also observed a gray Mercury minivan in the driveway that appeared to be inoperative and without a valid license plate on it. There's also another vehicle that had 2 tires that were on the parkway grass. I made contact with a resident, spoke to Glenda, and explained the issues that we had, and we agreed to a reinspection date of November 8th. On November 8th, Mr. Johnson came to the office here at City Hall, advised he's in the process of getting the vehicles moved around and repaired and has a limited income. Spoke with him for a few minutes, and we agreed to have a reinspection date of November 17th. My inspection on November 17th revealed that the only changes that had happened was the vehicle had been removed from the front yard, and there was no longer any vehicles parked on the parkway grass, but the silver minivan was still parked in the driveway without a valid license plate. Issued a notice of violation with a compliance date of November 28th. On the 28th, again, good there, and the van is still present. There was no, actually with the violation, rather, there was no response at the front door, so I posted the notice there on the front door of the residence, requested that the city clerk post a copy at City Hall and also mail copies, both certified and regular mail, to the listed owner. My inspection on November 29th revealed that, again, the red Honda wasn't there, the parkway was free of other vehicles, but that Mercury was still present. As of this morning, that vehicle is also still present in the driveway in the same condition without a valid license plate. And I'd like to submit the photographic evidence. Exhibit 1 shows the rear of the vehicle lacking the license plate, and exhibit number 2 shows the placement of the vehicle in the driveway.
Board will accept. Are there any questions for Mr. Buckland? No questions? Thank you, Mr. Buckland.
Thank you.
Call for a motion, please.
I'll make a motion, Mr. Chairman.
Mr. Allen?
Based on the testimony of Code Compliance Officer Steve Buckland, presented to the board at this hearing, the documentary evidence received by the board, I make a motion that the board find James Stevens and Glenn Johnson in case number 17-2746 to be guilty of violating section 12-924 of the city code, and give the respondents until January 10th to come into compliance with the code sections in question. If the property is not brought into compliance by that date, a fine of $50 per day shall begin to accrue on the day following compliance and continue to accrue until the date that the violator provides the city with evidence that the property has been brought into compliance.
We have a motion. Do I have a second?
I second.
Second by Mr. Westphal. All in favor?
Aye.
All
I'm
opposed?
sorry,
Nay.
could you tell me the amount of the fine again?
$50 per day. Next case, please.
Case number
I'm sorry for him,
172766,
said he was limited.
City versus Peter A. Schumacher for property located at 9619 North 55th Street. The case is before the board based on alleged violation of section 10(3)B sanitation grass weeds and section 12921 parking residential property. The case will be prosecuted this evening by Director Brony. The city has evidence that the notice of violation and notice of hearing were properly served.
I'm trying to read this as fast as I can, so. Tom Baroni, Code Compliance. This case this evening originated proactively on November 1st, 2017. My inspection that morning noted 2 vehicles parking on a non-durable surface. I also noted that the weeds were overgrown in the front yard. At that time, I left 2 door hangers with a reinspection date of November 6th, 2017. On my reinspection on the 14th of November, noted no change. Therefore, a notice of violation was prepared and posted at the front door. I also requested copies be sent out first class and certified mail. I also requested a copy be posted at City Hall for the 10-day requirement. On my reinspection on the 27th of November, noted no change. At this time, I'd like to submit photographic evidence of the violation that was taken by me on November 27th, 2017.
Board will accept.
That photo exhibit number 1 shows 2 vehicles parking on the grass, and the front yard is overgrown. The yard has been mowed, and the vehicles all week have been parking in the driveway. So therefore, the property is in compliance, and I'd like to submit an affidavit of compliance.
Board will accept. Are there any questions for Mr. Barone? Thank you, Mr.
Thank you.
Call for a motion.
I'll make a motion, Mr. Chairman.
Mr. Allen?
Based on the testimony of Code Compliance Director Tom Barone, presented to the board at this hearing, and the documentary evidence received by the board, I make a motion that the board find Peter Schumacher in case number 17-2766 to be guilty of violating sections 10-3B and 12-921 of the city codes, and give the respondents, oh, I'm sorry, I was reading the wrong one. This is a finding, wasn't it? Based on the testimony, because the property has been brought into compliance before the date of this hearing, no fine shall be assessed.
Second.
I have a motion and a second by Mr. Stats. All in favor?
Aye.
Opposed? No nays. This is one we've been looking for.
Yeah. Kind of, sort of.
Repeat
Miss-
case,
Has it pulled?
I'm gonna say in a second. Repeat case number 172794, City versus Yusef Hadjabari for property located at 104 Mission Hills Avenue. This case has been pulled from the agenda, and Director Barone will comment.
This property is, everybody's aware of this property, but I do have great news. As of 5 o'clock today, Amir Anisi approached me, and there is a third contractor that now is involved in this property. So, there's a porta potty that's on the property that we have had moved from the right-of-way back up to the structure of the home, whatever's left. But there is a new contractor, and on Tuesday of next week, he'll be in pulling permits to finish this. So I did pull this from the agenda tonight, and
Okay.
hopefully keeping my fingers crossed and see what happens.
Are we all open for that Tuesday morning?
Yes, well, don't bet on it, though.
Thank you.
Thank you.
Did the previous contractor?
Okay, we're moving to unfinished business, but I need to take a little break. So I'll let you guys go on. I'll be back. Go ahead.
Case number 171658, City versus Fadi Hamad for property located at 10318 Council's Way. An affidavit of compliance for section 12860 was submitted, dated November 9th, 2017. Case number 171607, City versus Judy Flynn for property located at 6709 Jennifer Drive. The expiration of compliance is tonight at midnight. Case number 171871, City versus Zoe L. McIlwain for property located at 402 Dunedin Avenue. The expiration of compliance is tonight at midnight. Case number 172038, City versus Carolyn P. Heron for property located at 7507 Wakula Drive. The expiration of compliance is tonight at midnight. Case number 172144, City versus Mary Hirschfield for property located at 714 East River Drive. An affidavit of compliance for section 810213C was submitted by Officer Silva, dated December 12th, 2017. Case number 172404, City versus Martha L. Wilkerson for property located at 8004 Eastleigh Court. An affidavit an affidavit of compliance for section 12921 and section 12858 was submitted by Director Brony dated November 14th, 2017. On that same case, an affidavit of compliance for section 810213C, and the expiration was today. An affidavit of compliance was submitted by Director Brony. And I have an affidavit for a case not on the agenda, case number 172404, City versus Benjamin, and Amanda Payne and Don and Peggy Graham for property located at 8208 Volusia Place. An affidavit of compliance for section 12861B7 was submitted by was submitted dated December 6, 2017. And that's all I had.
Okay, the recommendation of the lien reduction is going to the December 19th, 2017 council meeting, and I will not be able to attend that meeting. And I ask if Vice Chair, Jamie Stats would attend in my presence, in my absence. And you're probably, hopefully you'll have more success than I have. So,
I should be able to do it, but I'll double check, but I should be able to.
okay. Okay. And if you can't, I maybe can do it in writing.
No, I should be able to.
Yeah, thank you. Okay, new business. Are we ready for new business? We have a,
Well, I just, on behalf of the city of Temple Terrace, I would like to present Tim Garding with a plaque in recognition of his dedicated service and knowledge and commitment to the city. Not only Tim's been a mentor for me, but he's also been a friend, so he's going to be missed.
Thank you so much.
You're very welcome.
Thank you so much. I was not expecting this.
Mr. Tim Garding. I get to present it, I guess. So I want to thank you for your service and your guidance through my career here on the code board. And because you've been here about as long as I have.
I think so. Yeah, I think so.
So it's a pleasure. I
Thank
you
you.
again for your good words.
Thank you so much. This is very, very nice. If I may say a couple of words, I've really appreciated my time here handling code enforcement hearings for almost since I got out of law school. I've been here doing this, and I tell my friends all the time that I do all sorts of handle all sorts of cases at the firm, but this is one of my favorite things I get to do. I call it legal lab. So many issues intersect with code enforcement issues, touches all areas of law. And it also shows you, I think in many ways, the nobility in local government and the ability for citizens to bring complaints and be heard by a panel of dedicated public servants. So, and I think there's a legacy here at Temple Terrace, which I think is important. I recently had a chance to speak with our representative, Kathy Castor, who represents part of Hillsborough County, part of Pinellas in Washington, D.C., and she also used to be the code enforcement attorney for the city of Temple Terrace many years ago when Ted Taub was the city attorney. Thank you so much for giving me the opportunity to do this. And I think Mr. Newkirk and Mr. Schmidt were sitting on the board when I first started doing this. So it's been a great honor. This is completely unexpected. Thank you so much.
And you stayed with us.
I sure did.
I'd like to have all the other board members come down
We can just get a picture of
for
it.
a picture.
Thank you so much.
If you'll bear with us.
Very, very nice. Completely expect of him.
He deserves it. He deserves it. That's the least we can do. Everybody okay? Tighten up.
Yes.
Hey, come on, man, Chris, yeah. Maybe I need to go and get it.
Very good.
Thank you. Well, thank you again very much. I really appreciate it. We're gonna miss you guys.
So there was two other things I had on my list, and one was, of course, to give Tim the plaque, and two was to introduce Pam to our city staff, and want to welcome Pam. And also, I'd like to introduce Tina. Tina is our administrative assistant, just came on board about a month ago, and she's fitting in very well with the group that we have, and it's a big help to me, so I just wanted to introduce Tina. And also, I just want to wish everybody a Merry Christmas and a Happy New Year, Happy Holidays, and we'll see you next year.
Thank you.
Okay? Thank you.
I want to take this opportunity to thank Tina for staying with us to do the camera thing for us. I appreciate it. Thank you. Okay, there being no other new business, I would like to call for a motion to adjourn. Any? Hey, we loving it here. A motion?
I'll second that.
Motion seconded. All in favor? Aye. Thank you, guys. Merry Christmas to all.